Welcome, everyone. I'm Lee Meriwether, and with me is Todd Orston. Todd and I are partners at the law firm of Meriwether and Tharp, and you're listening to Meriwether and Tharp Radio on the new Talk 106.7. Here you learn about divorce, family law, tips on how to save your marriage if it's in the middle of a crisis, and even from time to time, tips on how to take your marriage to the next level. If you want to read more about us, you can always check us out online at AtlantaDivorceTeam.com. Well, Todd?
We're going to have to pick up the excitement level here. That was
just...
Yeah, we're going to have to pick it up a little bit.
Okay.
So how excited are you about this show?
I'm very excited.
Yeah, that's still not doing it.
It's going to be a great show.
There you go. Okay. All right. So I'm pretty excited, too.
You know, what's interesting is that we've never talked about this before on the show, and we've done it over 2 years.
Yeah, I know. And what's amazing is that what we're going to be talking about, we're being very cryptic here. What we're going to be talking about is commonplace, and it's becoming even more so, meaning it is something that is it's a tool commonly used in family law, and it's something that really a lot of people should be considering, especially if I'm going to give away a little bit, if they want to try and avoid the unnecessary litigation that sometimes comes with a divorce. So since I've given a little bit away, what are we talking about today?
We're talking about antenuptial agreements,
also known
as prenups.
Prenups. That's right.
So today we're going to talk about what are prenups. We're going to give a little history of prenups because I think it's kind of interesting how the law has evolved in that area.
Yeah, they started with cavemen. Yeah. I read that somewhere. That might not be right. All right, never mind. Just keep going.
Who might want one? What does the court consider when enforcing a prenup? Best practices when it comes to preparing one and making it enforceable? And, what kind of clauses can or cannot be included? And in order to go through that, we figured we would pull some celebrity prenups that we have read about over the years and sort of analyze them. And some of them we're not sure if they're real, and we're not sure if it's just some sort of tabloid trying to claim something. But anyways, we're going to take those examples and analyze them as to whether it would be a legitimate clause in a prenup.
Good idea. I'm in. I mean,
great.
Count me in.
I'm glad you like it. All right. So, Todd, what is a prenup?
So, very basically, a prenuptial agreement is an agreement that you can reach before you get married. And the whole purpose of that document is you are entering into an agreement or contract that will establish rights and obligations in the event of a divorce. Right. So really what you're trying to do, and the reason I was saying it, that it's an important tool, especially if you want to avoid litigation, you can deal with a myriad of topics and issues that typically and routinely come up in divorces. There are some that you can't. We'll go into those. But issues of alimony or spousal support, issues of division of property. You can protect assets that you have, or you can, if you have no assets at the time, you can still, meaning if it's a new marriage, you haven't accumulated anything, you can deal with who's going to get a house, who's going to get bank accounts, who's going to get different assets that you accumulate. And the reason that that's a powerful tool is because as attorneys know, anybody who has watched Law and Order, and not Law and Order, but I guess LA Law and other divorce shows. I just dated myself with LA Law. But it can get ugly.
Yeah.
Right? It can get nasty. Even though we like to say divorce hurts, it doesn't have to be nasty. It can get nasty. And by entering into a prenup, it can avoid some of that fight, if not all of that fight, because at that point, there's no fight. We've already dealt with how alimony will look. We've already dealt with division of property, division of debts. And at that point, hopefully, it's an easy transition.
Yeah, unless there's children. So
of course, right. And that goes to things that you can't handle.
Right.
And things like child support, child custody, those types of things cannot be handled in the context of a prenup.
So, and we're strictly talking from a legal perspective, not any other perspective. So, are the advantages of prenups from a strictly legal perspective, from more of a philosophical question of whether it's a good idea or not, that could be debated. So,
and it's a difficult conversation to have. I'm not going to downplay the difficulty that, you are, starting a relationship, starting a life with someone, and it's like, hey, honey, I love you. I can't wait for us to get married. Can you sign here, yeah. Initial these pages,
yeah.
And by the way, you'll get nothing from me when no.
Right.
So
it creates this, are you really all in on this marriage if you're holding back? But I don't want to get into that. That's not what we're going to talk about
No, that's
today.
not what we're going to talk about.
So,
but my comment was simply to show we do recognize it can be a difficult conversation.
Yeah.
Because you're having it at a time when things are fantastic between you and your soon-to-be spouse, but you have to talk in terms of a contemplation of potentially this relationship won't work and we may end up in a divorce. But when you couch it in terms of, but if that happens, I don't want to fight.
Right.
Let's try and avoid the fight. And that's where it just comes down to negotiating and making sure that both parties are being treated fairly.
Yeah. And I've seen the times where I've seen it seem to work really well is like second marriages where people they're coming from different places. They're all in, and I don't want to jump ahead, but I mean, I've seen situations where they enter an agreement and they're like, look, if we think we love each other, I mean, we're pouring ourselves into each other, but if we get a divorce in the next 10 years, then this is how we're going to split things. But if we go past 10 years, this agreement's null and void. So I've seen people that say, hey, after
Absolutely.
10 years, we're all in.
Yeah, and usually in those second marriages, they've either already accumulated assets that they want to protect,
right,
and they've also been through a divorce. So they know that as good and healthy as they believe their relationship is, sometimes relationships end, and they've been down that road before, and they don't want to once again get caught up in an ugly divorce proceeding.
So the description you gave of prenups is really what people think about today. But years ago, those prenups actually were not, they were against public policy. So the only prenups you could enter into years ago, so this is before the 1970s, and this was apparently across the entire United States, were agreements that were anticipation of marriage. So you could talk about, how you were going to combine things and, how you were going to organize your finances. I've even heard of agreements that had date nights built into them. That was part of it. But as soon as it mentions at the point of a divorce, here's how we're splitting everything up, it made the agreement null and void.
Because it was in contemplation of divorce rather than contemplation of the upcoming marriage.
Exactly. So that made it invalid until 1982, at least here in Georgia. And then
basically between the disco and this case law, you're going to talk about crazy times.
Crazy time. So in 1982, a case came out, Scherer, and am I pronouncing that right? Scherer. It's the Scherer test. Yeah.
Sure.
So Scherer.
Sorry, that was terrible.
That was terrible.
I must formally apologize to everyone listening.
That was terrible. So it's spelled Scherer, and it is still called the Scherer test. It's the test that's applied to prenuptial agreements to determine whether the court's going to enforce them.
It's a Georgia case.
It's a Georgia case,
right.
Yes. So, but what was interesting is, when this case came up, that I'm actually going to read from a portion of it because I think it's very interesting. So there can be no doubt that the institution of marriage is the foundation of the familial and social structure of our nation, and as such continues to be of vital interest to the state. But we cannot blind ourselves to the fact that the concept of the sanctity of a marriage as being practically indissoluble once you enter into, held by our ancestors only a few generations ago, has been greatly eroded in the last several decades. So this is what the Supreme Court's writing. And
you had me at hello.
That was one long sentence, too. Oh, my gosh, that was a long sentence. This court can take judicial notice of the fact that the ratio of marriage to divorces has reached a disturbing rate in many states. So next time I'm going to try to summarize this.
Yeah, I think that's a good idea.
It made sense when I was reading it, but when I read it aloud, I'm like, this is one long sentence. No, so what they were actually looking at the state of our country, and in the case, they did some analysis going, well, up until this point, almost all the states said, we're not going to enforce these. They are against public policy. But they said that with the advent of no-fault divorce, we need to change our policy.
Yeah, because they were probably getting bombarded with litigation and things are resulting in long trials. Why wouldn't they then say, you know what, maybe it's a good idea to let people contract at the beginning of a relationship in a way that it may, limit or prevent prolonged litigation at the end.
And, there's sometimes when doing that, I think, can be advantageous because we've seen cases where they never really talked about having kids. And then when they got married, all of a sudden one party didn't want kids and it caused a divorce. So, having that a conversation about all kinds of aspects of your future together is really important. And up next, we're going to talk about some other things that are really important, like who might want a prenuptial agreement and what does the court look at when determining whether it's enforceable. What is that Scherer test? Welcome, everyone. I'm Lee Meriwether, and with me is Todd Orston. Todd and I are partners at the law firm of Meriwether and Tharp, and you're listening to Meriwether and Tharp Radio on the new Talk 106.7. If you want to read more about us, you can always check us out online at AtlantaDivorceTeam.com. Well, today we're talking about something we actually have never talked about on the radio show before, even though we've done it for over 2 years, and that's prenuptial agreements. It is something that's becoming more and more commonplace today. And in the last segment, we talked about how years ago, back in the late 60s, early 70s, it actually was not enforceable. Somebody could enter a prenup in the anticipation of divorce, I should put a caveat, and it was not enforceable back then as against public policy. But the Georgia Supreme Court here in Georgia and across the whole country took a reevaluation of it and decided that it was no longer against public policy and came up with a test as to whether a prenuptial agreement in anticipation of divorce was enforceable.
And that would be the Scherer test.
Yes.
And that's based on Scherer v. Scherer. And when we say a test, basically the court came up with 3 elements, if you will, that need to be looked at and considered by a court in the event parties present the court with a prenuptial agreement. And also, let me say, I just want people who are listening to understand, at least here in Georgia, we keep saying prenup, but I wanted to at least very quickly at the beginning mention that there is also such a thing called a postnup. Okay. And a prenup is you haven't married yet, but you enter into an agreement.
Right.
But parties can, after the date of marriage, enter into a similar kind of an agreement, and that's called a postnuptial agreement. All right. We're going to be saying prenup, but I at least wanted to clarify that. So now getting back to the Scherer test, based on this case law, the court basically came up with these 3 elements. You want to tell everyone what the elements are?
Sure. So the first element is, was the agreement obtained through fraud, duress, or mistake, or through misrepresentation or nondisclosure of material facts? The second one is the agreement unconscionable? And number 3 was, have the facts and circumstances changed since the agreement was executed so as to make the enforcement unfair or unreasonable?
All right. So why don't we, there's a lot to sort of unpack.
Right.
But let's just go through very quickly 1, 2, and 3 and just sort of highlight what the court's really looking for or looking at when applying the Scherer test. So go ahead. I'm sorry.
So important, if you're listening in another state, there's a lot of states have their own sort of test, and it's based on the case that went up to that particular Supreme Court. So, and I can't, for the life of me, I can't remember what Florida's seminal case was, but the Scherer test is only in Georgia.
Yeah.
So if you're in another state, it is important to, the reason I bring this up, because in Scherer, the parties actually, it said that it was going to be interpreted according to Michigan law. But the Supreme Court said that, and they said a few other things. I think the parties may have said, I want Georgia to interpret it. But the court said, even if they wanted it to be Michigan, we could refuse to enforce it under Michigan law because it's a public policy issue here in Georgia. So just that caveat, you could actually have some case law that's really good, and then when you go to the Supreme Court, all of a sudden they could change things, saying, well, we think that the public policy has now changed, and we're not going to enforce these things anymore.
Right.
So I didn't mean to go off on that side note. I just wanted to make sure we hammered that.
2 thumbs up, Lee.
Thank you. All right, so let's get back to the agreement obtained through fraud, duress, mistake, or through misrepresentation or nondisclosure. When you do a prenup, and I want to say it's in every state, yeah, but I know for a fact that at least in Georgia, both parties have to sign a statement basically of their net worth, their assets, their liabilities.
A financial statement.
A financial statement. So there's full disclosure. And the concept being somebody says, hey, can you sign this? And I'm really not worth anything. And, oh, okay, yeah, I'll sign this. And it turns out they're worth $100 million. And the person says, well, they tricked me into signing this or something along those lines. So that's that whole fraud mistake. And
disclosure of material facts.
Yes.
Right. So, yeah, and going back to fraud, duress, mistake, fraud, obviously, we're talking lies.
Yes.
That information that one party provided was misleading, false. It was a lie. Yeah. Duress, what people need to understand is duress in the eyes of the court is not, if you don't sign this, we're not getting married.
Yep, correct.
That's not duress. Duress is, if you don't sign this, I'm going to hit you repeatedly with this rake.
Yeah, or holding a gun to your head, or
physical violence. Jokes aside, something where there are legitimate threats to your physical safety or life,
or a family member's,
or a family member. Correct. That you are then under duress. You feel like you have no choice but to sign. That would constitute duress.
But apart from that extreme circumstance, I've never heard of a prenup being overturned because
I haven't either.
Somebody saying, "Well, he gave it to me literally an hour before we got married." That's still not duress.
Yeah, because usually when people say, "Oh, I was under duress," they either don't have an attorney, okay, and they believe that something constitutes duress that didn't. Like, in other words, well, I'm pregnant and we're going to have this child, and I'm being told if I don't sign that we're not getting married, and I need to, be married for my unborn child. I felt pressured. Pressure does not equate to duress. Duress is a physical threat, and if you don't do this, these bad things are going to happen to you. And then there's a mistake of fact. Basically, you were relying on some piece of information and you genuinely it was a mistake. You entered into it. You thought one thing. It turns out it was something else. That also is very difficult because you have a burden when you're entering into an agreement to do your due diligence, to basically investigate and make sure that you're educated and fully and completely and correctly understand the terms that you are entering into. But nonetheless.
But if someone leaves off an item, like I'm not sure there's an affirmative duty to say, you know what, I'm going to do a background check on you to make sure you disclosed all your real estate.
Right.
But if you look at something and something looks kind of off, maybe you're supposed to investigate that. But, and there's actually some dispute. It seems like you read one case and the court says, well, no. That person should have investigated a little more. In the next case, that person doesn't have a responsibility to investigate. So each case is very factually dependent.
Yeah, and there's a big gray area when it comes to enforcement of pre- and post-nuptial agreements, at least here in Georgia, meaning, like, let's get to the next one because there's a big gray area. It was narrowed some by another case after Scherer that we'll talk about, but there's a gray area still about unconscionability.
Well, when we say gray, I want to be clear, like, most of the time we see prenups enforced. So
correct.
When we say gray area, I don't want people to think, what, they're not enforceable?
There's room for argument. What I mean by a gray area is that it's not black
clear.
Or white kind of thing. Yep. That, you have a signed agreement, then it will be enforced. This whole test is because of that gray area, or maybe you could even argue it creates that gray area.
Yeah.
Because these are all ways to avoid the enforcement of an agreement. And if you entered into an agreement before you got married, in your mind, you're like, all right, well, I'm locked in.
Yeah.
Right? It's a contract. I signed, he or she signed. We're done. So if we do get a divorce, we're bound. No. You have the Scherer test, and what that Scherer test is to determine whether or not that agreement should be enforced at the date of a divorce.
Yes.
So unconscionability. What's unconscionability?
I'm not sure if I have an example of one because every case that I've ever seen someone argue that they have failed. There may be one out there that I'm not aware of that I've just missed, but they don't hold up. That argument doesn't hold up because
we are on the radio, so you may want to come up with something.
But unconscionable, usually people will say, well, you know, when I got married, I was only worth $10,000, and now we're getting divorced. I'm still only worth $10,000, but he has gone from $4 million to $25 million. So that's unconscionable.
If I had to come up with my own definition, I would call it or refer to it as gross unfairness.
Yeah.
That basically I entered into this agreement. Facts have changed so dramatically that it would be patently unfair.
No, that's number 3.
Yeah. Well, yes.
We're focusing on number 2.
Yeah. Well, okay. I'm blending. Okay.
Oh, I would have given a different example if I know we were blending.
Right. There's a little bit of blending. It's I'm a blender. But that right now that the terms on their face are just unfair for them to be applied and enforced right now. It would be unfair.
Right.
And that of course leads us to number 3.
If the facts and circumstances have changed since the agreement was executed so as to make its enforcement unfair and unreasonable. Let's actually break down that a little bit more, of just number 2, the agreement being unconscionable, so we get some clarity there and avoid some blending so I don't get confused too. We'll be right back. Welcome, everyone. I'm Lee Meriwether, and with me is Todd Orston. Todd and I are partners at the law firm of Meriwether and Tharp, and you're listening to Meriwether and Tharp Radio on the new Talk 1067. If you want to read more about us, you can always check us out online at AtlantaDivorceTeam.com. Well, we've been talking today about prenups, and we started off going over the history of them, how originally a prenup that was drafted in anticipation of a divorce was unenforceable some 40 years ago or so. And today, well, maybe 50 years, and today it is enforceable, and we're talking about what the courts do, how the analysis that the courts here in Georgia in particular go through when deciding whether a prenup is enforceable. And, you know, from the cases I've read in other states, you know, the thought process is very similar from many of the states that I have read. I'm not going to talk about them because I don't have them memorized or anything. I'm going to focus on Georgia. But
and if you're in another state, obviously, listen to our show and then disregard most of everything that we've said. Go talk to an attorney in that state and find out what the law is there.
You get a general idea.
Absolutely.
Don't stop listening.
No, I said listen to our show.
Oh, and then disregard everything. Yes. I got you. Don't rely on it.
That's right. Then go find a local attorney and understand what the law in your state is.
Well, and don't actually rely completely on our show. I mean, we don't know the facts of your case. If you have a family law case, you need to talk to a lawyer.
Maybe we should move on. The next thing you're going to be saying is actually just stop listening. And no. All right.
No, I'm not saying that.
Okay. So we were talking about unconscionable. The last one was that facts and circumstances have changed since the agreement was executed so as to make its enforcement unfair and unreasonable.
And really, the only scenario that comes to mind that I've never seen this scenario, but I can imagine this scenario qualifying in number 3. So they enter a prenup, and then during the course of their marriage, let's say the wife has a stroke, and now
a medical emergency. Yeah,
she is now disabled. She cannot work.
She's been taking expensive medications. She's going to lose her insurance in the event of a divorce. She's going to, she contracted away the majority of the assets. The husband has the money, has been providing for medically speaking and just basic human needs. But the prenup would basically put her out in the cold and not give her access to the medical treatment that she needs. That might be a change of circumstances that would warrant basically no enforcement or refusal to enforce the agreement. So again, unconscionability is sort of, was it fair at the time that you entered it? I mean, when you look at the facts, is it just grossly unfair? Change of circumstances deals with an unconscionability type argument at the time that you are trying to enforce it. Have things changed so dramatically that it would be wrong on many levels to enforce this agreement? And
I would imagine a judge might like subconsciously go, okay, if I enforce this now, this person is basically going to become a ward of the state and create an expense, a burden on the taxpayers of the state. And so, but this person over here is worth $5 million. I could easily not enforce it, shift $1 million over to this person to have them taken care of.
Yeah, and on top of that, I think the argument comes in that there's no way that the parties could have, would have, or did contemplate a severe medical issue like a stroke, like something else that would put one of the parties who entered into this contract, that would put them into such a bad financial situation and maybe even affect their health and welfare. That could not have and was not contemplated all the way back then.
Right.
So at that point, the court potentially can say, okay, I'm not going to enforce this because right now enforcement would do such harm to this one party. And considering there's no way they contemplated this, I'm not going to enforce it.
Yeah. So still haven't seen one. The only thing
it's hard. I mean, I mean, it's because look at the extreme that we're talking about.
Yes. And the ones that we've seen, and it may have happened, it just never got appealed. And so you usually don't hear about them until they've been appealed in an appellate court.
Yeah. And so we've been talking about Scherer. There was another case that came out, and this was in 2005, Mallon versus Mallon. And in that case, there were some of these arguments. In that case, the husband at the time of the marriage, I'm just going to very quickly sum it up, made about, and I'm averaging, or I'm summing it up and summarizing, made about $500,000, a little north of $500,000 a year in income, and had, I want to say, somewhere between $4 and $4.5 million in assets. Got married to the person who became his wife, who was pregnant with their child, and from that point forward, his income was at the very least that amount. More than likely, it went up. But what did go up was the size of his estate. And it went up to I think it was about $11 to $12 million. And the wife, there was a prenup. The wife basically made all these arguments that there was a nondisclosure of information, that it was unconscionable because she was a waitress at the time that they got married and had nothing. And so he had so much, it was unfair and unreasonable and unconscionable to enforce that agreement. And there was a change of circumstance because clearly, his estate tripled, in size. And therefore, I should get something at the very least. I think what she ended up saying was, forget about the assets. I can deal with the assets, but I need some alimony.
Right.
So the bottom line is, that the court looked at all these things and ended up enforcing the agreement, and basically denied her request, on the appellate level. But I'm just saying denied her position that it should not be enforced.
Yeah, and there was actually a dissent in that case. So it was a close decision because several of the justices thought it shouldn't have been enforced, but it was.
And that was really based on the non-disclosure of information.
Of income. Wasn't it just income?
It was on income. So,
he supposedly disclosed all his assets.
He disclosed assets, and because I think my recollection was that because the issue that was being raised by the wife was, I need alimony to survive. Right. And income is a pivotal and important issue related to determination of alimony.
And in Mallon, weren't they married? I mean, they were been together for several years.
They were together for about 4 years prior to getting married. So basically, the minority who were dissenting basically said he didn't give information related to his income, and therefore there was a non-disclosure of material fact, and pursuant to the Scherer test, therefore, that agreement should not have been enforced. But the majority said no. They were together. She understood what his income was at the time of the marriage, and she had an obligation to look into these things. If she chose not to pursue that information, that was on her.
And what's interesting is, so in Blige versus Blige, which was 3 years later, that's Blige, there was a discussion where it said, in the absence of full and fair disclosure, the other spouse does not have a general duty to investigate the assets of the other party. So if you look at hyper-focus on the facts of these two cases, they look like they're different. But if you pull back and try to go, okay, what am I to take out of these cases? There seems to be a conflict, but not exactly, but
there are nuances.
There are nuances. So when you have these cases, you have to, find the case that closely fits. I'm talking about the appellate case or the Supreme Court case that closely fits your facts and circumstances when arguing whether something should be one of these prenups should be enforced.
Yeah, and let me also say this: as we've done shows on representing yourself, I'll be honest with you, we will oftentimes say that, you can represent yourself in a divorce, depending on the facts and the issues and all of that. These types of arguments are very, very technical.
Yes.
And so my recommendation to anyone listening who is dealing with an enforcement issue in an upcoming divorce, get yourself legal counsel.
Yes.
Because like I said, it's a very technical argument that your attorney is going to have to look at different case law and then apply that case law to your specific facts. And the court is going to want to err on the side of enforcement because it's a contract.
Yes.
What you're doing is you're looking at a judge saying, yeah, I know I entered into this agreement and I know I formally contracted certain rights away, but I want you to throw that away. Let's just pretend like that never happened. Courts don't want to do that. That's not, equilibrium for a judge. A judge doesn't want to throw out a binding contract, but this Scherer test is saying, okay, typically you're not going to do that, but here's a test. Apply these things, these different prongs of the test, because maybe you have to get rid of this contract because it was unfair, there was misrepresentation, something like that.
So, I've had these cases where I had one years ago where, and it had to go to trial and everything. It was interesting. The wife was the one who had all the assets, and she insisted our client sign it. But when it came time to enforcing it, she didn't want it enforced, which was.
I've seen that before. Usually it's kind of interesting. The facts have to be interesting. Let's just say that, because usually that person in that situation would want it enforced.
Yeah. So, hey, up next, we're going to actually talk about some best practices. So if this is something you're considering, what should you do to make sure you enter into a enforceable prenup? Welcome, everyone. I'm Lee Meriwether, and with me is Todd Orston. Todd and I are partners at the law firm of Meriwether and Tharp, and you're listening to Meriwether and Tharp Radio on the new Talk 1067. If you want to read more about us, you can always check us out online at AtlantaDivorceTeam.com. All right, today we've been talking about prenups, and we started off with a history of them. We got the last two segments. We kind of got deep into the analysis that the courts have done. We've talked about how they're very fact-specific, and sometimes you might look at two cases, appellate cases. That means that at the trial court level, a decision was made and somebody appealed it to either the Court of Appeals or the Supreme Court, depending on the type of case. And at least that used to be the rule. So they're very fact-dependent. So sometimes you might look at two cases and seem like, well, wait a minute, do those conflict with each other? But not necessarily. All right. Let's talk about best practices. What should you do? Let's talk about practical stuff. What should you do to make sure your prenup is enforced?
Well, let's start with if you're in Georgia and you are drafting this in Georgia, of course, you're going to apply Georgia law. You have to understand Georgia law.
Yep.
But what I will say is, going to what you said earlier, the laws of each state might be and are oftentimes different. So you have to understand that if you're both here and you're entering into the agreement here and Georgia law will apply, great. But we've had people who are contemplating a marriage and they are talking about, then they come to us and they say, hey, we want a prenup. Oh, and by the way, as soon as we get married, we're moving to Kentucky.
Right.
Okay. Well, if you're not planning on living here and you already have an idea of where you're going to go, I will tell you, you should probably contact an attorney in that state to make sure that the way Georgia handles things in terms of a prenup and applies the law in relation to the enforcement of a prenup is similar to the law in Kentucky, let's say. And if Kentucky requires something different or something additional, then you can talk to your Georgia attorney who is preparing it, and you can add that language to make sure that in the event of a divorce, when you're both 5 years, 10 years, 20 years in Kentucky, and Kentucky law will apply to the divorce, that the laws of that state have been complied with.
Now, you can also include a choice of law clause. So you could say, look, no matter where we move to,
correct,
this is going to be interpreted under the laws of the state of Georgia.
Right.
Now, that doesn't mean you don't run into problems in other states, because like I said, when this case, the Scherer case first came out,
that's right,
it was the choice of law was Michigan, but there was a public policy against enforcing them. So the Georgia at the time could have said, we're not enforcing it.
Correct. And building on that example is why you just need to understand and know that you can elect, and oftentimes we do, that Georgia law will apply, but you may want to at least familiarize yourself with the laws of this state that you're going to be moving to, just in case there's something that could affect the enforcement.
So, all right, the second thing is don't wait to the last minute to do it. There's several reasons for that, but the first reason is you don't want to give that argument, whether it fails or not. You don't want to give let someone have the argument, oh, I was under duress, because people still make it, even though the law is pretty clear on it, in my opinion at least. I still see people make it. So do it several months. If you can do it 6 months before your wedding, great. And have a discussion, not just about your finances, about all kinds of things, but do it 6 months in advance before.
And sometimes that's not possible. We understand that. We have clients come to us all the time, and they're like, hey, my wedding is 3 weeks from now or 2 weeks from now. Can we do this? And the answer is yes, we can. So just because you're doing it at the last minute doesn't mean it can't be done,
right?
Or that it's not going to be enforceable. What we're saying is that it builds certain arguments in that somebody might wrongly, but somebody might still make an enforcement argument regarding, let's say, duress, or lack of, a failure to disclose if you're doing it in a rush and things aren't disclosed properly. So you don't want to wait till the last minute. Best practice, as much time as possible. But that I'm not trying to dissuade people from entering into a prenup, even if their marriage is around the corner.
Right. But you make an excellent point. So the reason not to...
I appreciate that.
You do it every once in a while. So the reason you want to do it in advance is, number one, to avoid the argument of duress, but number two, avoid the possibility of not properly filling out your financial statement. And so the next thing is, do your financial statement well in advance, triple check it, triple check it, quadruple check it, because that is where I see most, I see every one I've ever read was where the court found that there was not a full disclosure of assets and liabilities.
Or that it wasn't accurate. Or you prepared one, and then you start digging in, and you see that there were dramatic differences between what the actual value of accounts were and what was put onto the financial statement.
Right.
So make sure it's accurate. Make sure it's comprehensive. Make sure if you...
have someone else double check it for you.
Absolutely.
Like if you have an accountant that knows a lot about you, or a financial planner that you work with, have them double check it for you. So that's a huge one.
All right. Next, I would also say each party should have their own independent attorney.
Absolutely.
All right. And for a couple of reasons. First of all, you need someone that you can speak to that is protecting you. All right. Because this is a contract. These terms can affect you for years and years and years to come, and materially affect you. You may be giving up alimony rights. You may be giving up property rights. So it can carry with you for years to come and affect your life. So make sure you have somebody who is dedicated to you, that represents you.
Yeah.
One attorney can't represent two parties and give both of them the strong advice and counsel that they need, it's a conflict.
Well, and if you really want it enforced, you don't want the other person to say, oh, I thought this person was representing me and now I found out they weren't. So that's a fraud.
That's right.
So it's worth the extra money to pay for two lawyers to be involved because it helps to eliminate the defenses that you may run into later on in court.
And if you hire the right attorney, it doesn't mean it has to be a fight.
Right.
You have to, that's where we've done shows on, you have to interview the attorney, make sure that they understand.
Mm-hmm.
I want good counsel. I want you to tell me right from wrong. But at the end of the day, I'm not looking to have this break down and me not get married.
Yeah.
So, if this is horrible, tell me. I'll make some good decisions for myself. But you don't want somebody who's going to try and fan some flames and turn it into something it doesn't need to be.
So another practical tip is when you're preparing your financial statement, go ahead and print up statements. So like if you're listing out, well, my 401k has $500,000 in it, print a current statement and attach it to your financial statement, because that goes to say, look, there was full disclosure. It helps you avoid mistakes. And here's the other thing it helps do. Let's say there was a huge upswing, and you put it in there and you just got busy with your wedding. By the time you got married, that $500,000 was now worth $650,000 because there was one of the stocks in your portfolio went through the roof. Well, they can't say you misled them because you had the statement attached.
Yeah, we're going to talk and we're going to talk in the next show we do on prenups, but about a celebrity case that is similar to this. But, if you write on the back of a napkin, this is our prenup, and you both sign it, as opposed to you have a full comprehensive agreement with attached exhibits and all of that, one is going to be very enforceable. The other one, not so much.
Not so much. All right. So I'm glad you said that. The formality matters. So in Georgia, they recently changed the law. Last year, they changed it. 2018, depending on when you're listening to this show. Now it must be notarized and there must be another witness. So you've got to make sure you follow those formalities, because that is the other thing that I have seen some agreements thrown out on for failure to follow the formalities. So if the two of you sign it in Georgia, you could do everything else we talked about, but if it is not notarized and witnessed, it is unenforceable.
Yeah, and this goes to the courts, what I was saying before about courts want to enforce these contracts, but what they're doing is the courts have been putting these rules in place to say, okay, I want to enforce this, but you have to do a few things. You have to, follow these formalities. You need to, make sure that it will pass the Scherer test, all of these things. But as long as you do these things, it's going to be enforced.
Shoot, you know what? We have run out of time.
I blame you.
All right. Hey, we didn't get a chance to get to a few ththings, including what can and can't be in prenups. So
I think you mentioned it, though. I think we actually did mention it at one point.
Tune in next week, and we're going to get into those. We're going to take some celebrity cases, break them down, and we're going to get into some of those, what you can and can't do next time. I'm glad we set that aside. There's actually some other best practices tips. You can find them on our website. If you go to AtlantaDivorceTeam.com or MTLawOffice.com, go there, look up under our mega menu on the top, prenups, and you're going to see some best practices there. So if you're at that point, go check out our website. We've just scratched the surface in the show, and tune in next week to hear some more details with some fun facts from some of these cases, and we'll break those down and have a good time.
I look forward to it.
Good.
I'll be here.
Thank goodness. Thanks so much for listening.
This audio program does not establish an attorney-client relationship with Meriwether and Todd.